Hello, and thank you very much for attending this session on regulatory enforcement in Europe. We have an excellent panel for you today, made up of practitioners from the UK and France, who'll be discussing the approach taken by regulators, ways to deal with regulatory enforcement investigations, and lessons learned from enforcement cases in both of our jurisdictions. But before we go into any of this detail, let's quickly introduce the panel. Shall we start with Martin and then Guillaume?
Hi everyone, I'm Martin Letuzet. I'm a dispute partner at Herbert Smith Freehills in Paris, focusing on financial and regulatory disputes. I advise financial institutions as well as their managers in the context of investigations carried out by the French financial regulators, namely the AMF and the ACPR.
Bonjour à tous, my name is Guillaume Hannetin. I've been a barrister before the Supreme Court for the past 12 years, specializing in complex financial litigation and working, as far as regulation is concerned, at appeals level before all the relevant French and European courts.
Hello, I'm Andy George, and I'm a barrister at Blackstone Chambers here in London. I have been working in financial services regulatory cases for the last 20 years since they set up the new system with the FSA. Sometimes I work for the regulators and sometimes I work against the regulators.
Thanks very much. And I'm the moderator of the discussion. My name is Chris Ninan. I'm a regulatory partner at Herbert Smith Freehills in London. I've worked almost exclusively on FSA, FCA and PRA enforcement matters for the past 13 years, with a short interlude for a couple of years working on DOJ and SEC enforcement as well. So let's get on to our first topic, which is the current and future approaches of regulators in the UK and France. So shall we start with France? And Martin, can you tell us what the AMF is up to at the moment?
Certainly, Chris. Look, in France, two types of procedure are conducted by the French Financial Market Authority, the AMF. On the one hand, the inspection procedure, whose purpose is to ensure that financial institutions regulated by the AMF and individuals meet their professional obligation of good conduct. On the other hand, the investigation procedure, whose purpose is to ensure the application of market abuse regulation. So first, I'll deal with the inspection procedures. In 2019, there were 65 inspections initiated by the AMF on regulated entities. So 21 focused on investment services providers, about marketing of financial instruments, implementing the depository obligations. 36 out of 65 inspections focused on asset management company, about IFM reporting, internal controls, cybersecurity, AML, CFT, and 8 inspections focused on financial investment advisors. These regulated people are people who sell financial instruments outside of a banking group. I could give you the entire list of topics that are under scrutiny of the AMF, but it is a bit exhaustive, so I will move on to the outcome of these inspections. You have to keep in mind the following figures. In 2019, the inspections ended up with only a follow-up letter in 46 cases, and 14 cases were prosecuted before the Enforcement Committee of the AMF. 5 inspections are still outstanding. So the tip to keep in mind is that there is a 30% chance to be sued in front of the Enforcement Committee, 30%, which is big. The priority for the coming years in terms of inspection are for the banks, the investment banks, post-trade transparency, best executions. In terms of asset management company, the implementation of the delegation of permanent control, liquidity risk, and so on. For the financial investment advisor, it will be about marketing of financial instruments. So if I move on now to the investigation phase about the market abuses, you have to keep in mind that 46 investigations were initiated by the AMF last year. 24 were initiated by the AMF itself, and 22 were launched in the context of international cooperation with the FCA and other regulators. Over the 24 investigations initiated by the AMF, 16 focused on the insider dealing, 4 focused on market manipulation, and 4 were related to financial information of the listed company. What is the outcome? 17 investigations ended up with a follow-up letter, and 8 investigations ended up with a disciplinary proceeding. So the tip to keep in mind is that there is a 32% chance to be sued in front of the enforcement committee. So it is pretty the same figure, 30%, 32%. So 1 chance out of 3 to be prosecuted before the enforcement committee when an inspection or an investigation is open. What are the future trends of the investigation? I think that the big topic will be financial information and COVID-19, and I'll let you, the English side, tell us a little bit more about that. But as far as France is concerned, the AMF issued very strict guidelines regarding the immediate reporting of the economic impact due to the epidemic for the listed company, and I'm sure this is something that the AMF will focus on for the next year.
Thanks, Martin. And as you say, MAR, the market abuse regulation, and COVID-19 is a hot topic for the FCA as well. And it seems clear to me that this focus will lead to an uptick in enforcement action for those topics over the coming years. So the FCA has focused on the need for what it calls clean markets during the COVID-19 pandemic, and it's noted that listed companies and their advisors are going to have a lot more inside information than is normal during this time. And that could be because trading conditions or issues faced by companies count as inside information, or because firms are being more active in the market. So, for example, through fundraisings, which will often lead to a greater amount of inside information and a need to control that. So during the pandemic, the FCA publishes what it calls Market Watch publications, and it's encouraged firms on ensuring that inside information is appropriately identified, controlled, and disclosed to ensure that it's not misused for insider dealing or other nefarious purposes. And these quite strident messages from the FCA come after they set out their view in February that a number of firms lacked proper controls and understanding of their market abuse obligations. And it's my view, in light of that we're going to see more and more questions from the enforcement division of the FCA to listed companies and their advisors about this sort of thing. But before we move on to the other things that the FCA are looking at in an enforcement context, Martin and Guillaume, is there anything else that you wanted to add from a French context and from the AMF perspective?
No, I think we covered the current and future trends on that. So let's move on to the UK perspective.
Great. So in addition to MAR, the FCA's priorities, or their stated priorities, are likely to be the usual suspects, such as dealing with financial crime, and we're seeing a large uptick in financial crime-related enforcement investigations, ensuring operational resilience in firms, and again, we've seen a number of enforcement actions and a number of investigations that are focused on financial institutions' operational resilience, and also cleaning up consumer credit markets. On the consumer credit front, we've seen a lot of activity in a supervisory and enforcement context, particularly ensuring that vulnerable customers in a pandemic context are appropriately protected by the firm and by the regulator. Something that I think is new and that we are starting to see in practice is an FCA's focus on smaller firms. So in its business plan that it produced this year, it said that it is seeking to investigate firms that, what it says, consistently fail to meet the FCA standards. And the FCA says that it will move swiftly to enforcement action against those firms. So the regulator regulates tens of thousands of firms, but enforcement actions to date have tended to concentrate on the bigger firms, a number of whom will be in the audience for this talk. But the FCA has said now that they're going to focus on the smaller firms that have, to some degree, gone under the radar to date. I work in a space where the FCA investigates firms either at a supervisory level or an enforcement level. Andy, you see it from a slightly different level, and you see the FCA's actions at the RDC and upper tribunal stage. Is there anything you wanted to add here?
Yeah, and it's good fun to hear Martin's statistics, and I'll try and see if we can compare them from this side of the channel. The number of investigations the FCA do is hard to compare because the vast majority of FCA investigations, rather bizarrely, are for people who haven't paid their FCA fees, and they're what you might call administrative investigations. But what was interesting was you were using numbers about 15, 16, 17 of those that get to, I think, the investigation committee, those that get contested at a serious level. And here in the UK, the number of enforcement investigations that have led to contested actions before the RDC, which is our regulator's decision-making committee, has remained very constant at about 15 or 16 over the last 4 or 5 years. It's interesting that that's the volume. And the subject matter that you raised is pretty identical to what we have had here. We have listed companies, we have a lot of individuals with integrity issues, we have firms with big structural money laundering issues, but it's that number, I think, is much the same. Here in the UK, as you may know, we have a tribunal system, which is you can refer the regulator's decision to an independent court, which will have a full hearing under the traditional English procedure of live witnesses and cross-examinations and potentially very long hearings. There are far fewer of those, but a number of those that are going through. The other thing I think that was interesting, Chris rightly summarising from the FCA business plan, the phrase they want to move quickly against small firms. And I think here in the UK, one of the issues that comes up time and time again at these type of presentations in terms of market commentary is the speed with which the FCA is moving. They are being criticised for delay. In their recent enforcement review, it is over 3 years, the average case, even to get to settlement, and it says 4 3/4 years, where it goes all the way through the RDC and then up to tribunal. And that obviously means that a lot of the outcomes that we are seeing can be rather historic by the time they actually get to the tribunal. So I think in terms of where the regulator will be looking to go, it's not just moving quickly against small firms, it will be trying to move quicker against everybody. And there are 2 things, perhaps, Chris, I think that they're doing that really show their intent in that regard. The first, recently in the COVID-19 pandemic, is they brought a test case against a very significant number of insurance companies who had basically either been declining or intimating they were going to decline pandemic-related claims, and effectively forced them into court on a put-up or shut-up basis. We will have a very speedy resolution of these. And that will then mean people and businesses have certainty. And so far, it seems to have worked extremely well. The FCA got its case together, had a very experienced team that prosecuted it, the insurers defended it, and obviously with the cooperation of the English court, we have had an extremely lengthy and detailed judgment that came out very recently. It may get appealed further, but certainly it's far faster probably than we've seen before, and the FCA are using other forms of high court procedures, injunctions, speedy resolutions to try and move those forward. And finally, on this topic, in terms of the current procedure, in the last 2 years, the FCA have introduced what's called a focused resolution agreement, or FRA process, where they invite the subjects of regulation to agree certain matters. It may be they agree that they are liable, but dispute that the penalty should be as high as it is, or it may be that they agree the facts, but disagree that there is a regulatory contravention. And by having these partially contested cases, as they're called, obviously things have been able to progress much quicker, there's less need for detailed investigation, and this again is about trying to produce quicker and more efficient outcomes. I mean, so far there have been, I think, 3, 4, 5 of those are going through. 3 of them last year came out as big decisions, 1 went to the tribunal. So I think in addition to the subject matter, and of course COVID-19 is going to be massive, the FCA really are going to be looking to innovative and imaginative use of procedures to try and get even more efficient outcomes and quicker outcomes.
Yeah, and Andy, as well as quicker and more efficient. I think the regulator, or at least the people governing the regulator, want to get the best regulatory outcomes. And one of the reasons for the focused resolution agreements, as you suggest, is that a lot of firms, and particularly the firms that I represent, settle matters at an early stage, in part just to get things over with and move on with their business as usual activities. And what a focused resolution agreement allows them to do is reach a better outcome by agreeing some facts, but disputing the penalty, for example, because they think that the numbers that the FCA are suggesting aren't the right ones. And we know that Tim Parks, who's the chair of the RDC and a former partner of our firm, is very keen to get more and more of these focused resolution agreements before him, so that there is more oversight of what the regulator is doing, and more things are not settled through agreement between the firm and the FCA.
I mean, that's absolutely right, Chris. And I think it's not always a good outcome when a firm is willing to settle almost on any price, because although for the firm, they just want to sweep it away and get on with life, and they will pay what the regulator demands, you can end up with some fairly bizarre precedents that, when you look at them in other contexts, give rather strange messages. I think that's one of the ideas of the FRA, is to try and have more consistency by arguing about penalties.
There's been some interesting analysis of FCA penalties over the years, and I haven't second-guessed this analysis, but the conclusion seems to be that they tend to just somehow be made up on the spot, depending on the facts of the case, rather than having any particular precedential value. So it will be interesting to see if that changes over time.
Absolutely, and I'll just say on that, the FCA penalty policy, which is highly controversial and has some fans and quite a few critics, recently celebrated its 10th anniversary. So it's had time to bed in, and it'll be interesting to see how the analysis treats it.
Absolutely. Great, thank you very much all. I think that takes us to the second topic, which are strategies for interacting with the regulators and courts during the enforcement process. So as I said at the outset, a couple of us tend to deal more with the regulator at the pre-court stage and usually deal with settled outcomes, and a couple of us deal with the regulator at the court stage. So we'll probably split relatively neatly down those lines. As Martin said at the outset, both the AMF and the FCA split enforcement into these two broad stages. First, an investigation stage, which usually can lead to a settled outcome or no formal action, or a later stage where a committee looks at the merits of the finding and the level of the sanction. And that's the Enforcement Committee of the AMF and the Regulatory Decisions Committee of the FCA and EDMC of the PRA. And the decision of these committees can be appealed to more formal courts in both jurisdiction, which is where Guillaume and Andy's experience is very relevant in particular. But I'll kick off with the sort of strategies that I see being used with the FCA and PRA. And as I say, I deal primarily with firms that are in FCA or PRA enforcement, or at this pre-enforcement stage, where there is a risk that behaviour has taken place that could lead to enforcement, but no sort of formal enforcement steps have been taken. As is evident in the past few years, the FCA has increased its enforcement activity following its Director of Enforcement's edict that more investigations should be opened into potential serious misconduct, and that's the term of art that the FCA uses, but also that more investigations should be closed more swiftly where no formal enforcement action is required. And firms and their advisors, such as us, have reacted to that by working with the FCA and PRA in order to get to the best regulatory outcome for all concerned. And clearly, no firm wants to go into formal enforcement. So the first thing a firm can do is to try and seek to avoid that. The facts of a particular case may make enforcement action inevitable, but there are still steps that can be taken to ensure that the firm is in the best position it can be. In order to do that, being open and honest with the FCA is key. That means reporting the issue, ensuring the FCA is fully updated on what happened, why it happened, and what the firm is doing to address the issue. And where a firm seeks to address that issue themselves, they need to bring the FCA along with them. And that means keeping the FCA on board with the way that the internal investigation is being conducted. That includes the scope of such investigation and being very transparent about its findings. So in short, at this pre-enforcement stage, but also in enforcement, cooperation with the FCA is key.
That's very, very interesting because I will say a word later on about that, but this is pretty the same here in France, where cooperation with the AMF at the investigation stage is absolutely key if you want to maximize your chances not being prosecuted in front of the enforcement committee.
Great, thank you, Martin, and we'll look forward to that. So I mentioned what to do or how to seek to stay out of enforcement with the FCA, but there will be circumstances where you do just go into enforcement, particularly where the trigger is external or comes from the FCA themselves. And in those circumstances, the stance of the firm will depend on the type of case that's before them. So there will be circumstances where the FCA seeks to investigate an issue, but the issue is minor or it's clear to the firm that there hasn't even been a breach. So in those circumstances, we've got some good experience in practice in investigating the issue for the firm in order to prove that negative. And as I mentioned previously, it's important that the FCA is comfortable with the scope and method of any investigation before doing so. There's no point in doing an internal investigation if the FCA doesn't accept its findings and wants to do it again themselves. So you've got to get the FCA on board and then produce the findings with the FCA. And in circumstances where we don't think there really is a case to answer, we've had some good experiences with producing a submission to the FCA that details the facts of what happened, but also explains why no further action is required. And noting what I said earlier about the FCA wanting to close investigations where appropriate, this has a good chance of success depending on the facts of a particular case. On the other extreme, there are circumstances where a firm knows that misconduct has occurred. And as Andy mentioned earlier, that some firms just want to get things over with no matter what the price in order to return to their normal activities. And there are circumstances in which you can work with the FCA to accelerate a conclusion by investigating the issue. So the FCA needs to know the scope of the issue, remedying it, ensuring no similar issues are occurring or can occur in the future, and suggesting an appropriate remediation program. And we've had good experiences with the FCA bringing them along the whole way, but sort of packaging all of that up into one. And we've done that in circumstances, as I say, where the goal is just to close off the issue as quickly as possible, where that sort of particular business line no longer exists, where those executives have moved on, and where the new management of a firm just wants to get on with the business of running a company rather than dealing with the FCA on an ongoing basis. However, there may be circumstances where that's not what a firm, or particularly that's not what an individual who's being investigated wants to do. And rather than settle a matter as quickly as possible, the investigatee will want to take things as far as possible because they don't think that the FCA has a case against them, yet the FCA continues to bring that case. So then the investigatee will want to take things to the RDC or upper tribunal in the UK. Andy, from an English perspective, and before we go over to our French colleagues, do you have any reflections on strategies that firms or individuals can take at this stage, noting that, as you say, you act for both the FCA and people being investigated?
Yes, and by the time you've gone to the RDC, in a sense, haven't settled it because you've had the opportunity to have your 30% discount, and they have a very set in stone settlement policy. That's not a criticism, but it means that's always on offer at an early stage. But as you say, Chris, particularly if you have an individual who is facing a prohibition order that would effectively be career ending, often settlement will not be necessarily an option that's attractive. And I think when one's looking at the RDC and then the subsequent tribunal stage and tactics, it's very important to recognise how very different those two fora are. When you go to the RDC, or its equivalent of the PRA, the EDMC, and we're all having to learn these acronyms over the last couple of years, you are before an in-house committee of the regulator. They are sitting independently, only one of them, the chairman, is an employee of the regulator, but they are nonetheless making a decision as part of the policy-making body that is the regulator. And the hearings are relatively limited. They don't call them hearings, they call them meetings. And whilst you have an opportunity to present your case, it is within a limited forum, maybe a couple of hours, during which you have to say, as the lawyer, everything that you feel is the right thing to say in respect of that case. But also, almost certainly, you'll want to give your client, whether it's part of a firm or an individual, the opportunity to talk to that panel and explain that side of the story. So it's not a fora where you are going to get terribly far with highly complicated battles of technical evidence or a real he said versus she said conflict of fact. You really want to be identifying the knockout points, if you can, or the thematic points about why the FCA got this one wrong. Maybe they were looking at a particular theme and they've just taken the wrong example. Maybe they have misinterpreted some very key facts. And that's the RDC do reach decisions that are not just different to enforcement, but they have thrown out enforcement cases regularly. And they don't do it that often, but every year you look at the Enforcement Annual Performance Review, there's one or two. I've had several over the years where cases have been entirely discontinued. But if your case is highly factually complex, if it requires cross-examination, if you need your expert to be believed over another expert, you may well find, and tactically really perhaps want to have this mindset from the outset, you're going to need to go to the tribunal and you're going to need to develop that case over a substantial period of court time, and you're going to have to be prepared to win the case by demonstrating through cross-examination that the FCA, maybe they haven't, it's not the criticism of their analysis, they've simply believed somebody who should not have been believed, and it's only really at the tribunal that you have that opportunity to make that stick. And certainly, as Chris will know, the tribunal have repeatedly over the years reached different conclusions that of the FCA. I think in the last, even in the last couple of decisions we've had, in Mr. Tinney's case, there was a very different outcome on the facts, which the FCA found, having heard evidence. In the most recent one, they took a different view about whether it was reasonable for a particular firm not to be able to get PII in particular circumstances. So the tribunal really is that opportunity to, I mean, it's often said you're starting the case afresh. And so tactically, you really want to think about, is this a case I'm likely to win before the RDC, or am I really thinking about the tribunal at this stage? And as I said, Chris, and as everybody in this country knows, that can be quite a long process by the time you've got through all those stages. You need to know that, and your client needs to know that at the outset. Because if the tribunal's where you're going to win, you have to be prepared to dig in for the long haul.
Absolutely, Andy. And there are a number of circumstances where you've got a client that really wants to take it to the final stage because they really believe their case. But then when you tell them the time taken and the cost associated with it, their mind is sometimes changed by that. Thanks very much, Andy.
Are going to be so important because it gives a whole new opportunity to, and I think Tim Parkes absolutely wants them to see them used more imaginatively, not just we settle liability and we're arguing about the penalty, but actually just argue about particular facts or the legal consequences of particular facts, because it can be such a saving in terms of the investigation required in tested stages.
Absolutely. Thank you very much, Andy. Martin and Guillaume, do you have a French perspective on this for us?
Yeah, absolutely. Thank you, Chris and Andy, for your thoughts. Very interesting. I will deal first with the investigation, inspection stages, and Guillaume will deal with the more formal proceeding stage. There are three tips to keep in mind at the inspection investigation stage. First, corrective measures and remediation plans are always welcomed by the regulator. Indeed, when a finding of the investigator is indisputable, it is worth suggesting corrective measures rather than pushing against the AMF. However, the corrective measures do not absolve the past misconduct, but it's a way for showing good faith to the French regulator. Secondly, cooperation is taken into account by the enforcement committee when determining the amount of the sanction. There is no text, position, guidelines, or case law whatsoever providing clear guidelines on what level of cooperation is required and how it's taken into account concretely. I mean, this is far different from the very sophisticated FCA discount. In France, there is not such a table, not very clear about the amount of the discount. But it is mentioned in the text, so we have to cooperate. Third and final tip to keep in mind, lack of cooperation is a professional breach per se that could lead to disciplinary sanction. So there is case law in France, at least two precedents in 2020 and one in 2019, where the AMF fined a company for lack of cooperation. There is an important case law related to Elliott, the US-based fund, where the AMF judged that the delay in providing documents more than a year and a half and in a redacted form that was not allowed by the AMF is an obstructive offense, and Elliott has been sentenced for that. So this is the investigation phase. Cooperation is clearly a conduct that is expected from the regulator. What about the proceeding and the appellate, Guillaume?
Well, as far as appellate is concerned in France, there is an alternative, whether you are a regulated entity or a non-regulated entity. If you are supervised by the AMF, i.e. if you have a license signed by the French authority, your appeal goes directly to the Supreme Court for Public and Administrative Law, called the Conseil d'État, Council of State. If you are not regulated by the AMF, your appeal goes to the Paris Court of Appeal, and then to the section of the Cour de Cassation, Supreme Court in civil and criminal law, specializing in finance. So this is an important point to make at the outset, since in most cases, your appeal as regulated entities will be heard by the Council of State, i.e. people of high integrity, but with no finance background and a tendency to advise the states and the various public agencies of the public sector, rather than to hinder their action in any way. This bias against our clients that we have to face, and this rather lack of financial literacy, which prevents the administrative Supreme Court judges from grasping the acts, motivations, and constraints faced by our clients, forces us to develop sophisticated procedural arguments. As some of you might be aware, the French are world champions as far as technicalities are concerned. The Duke of Saint-Simon famously wrote about trials going on for decades under Louis XIV and Louis XV, based only on technicalities. So 125 years before Bleak House, and despite a great revolution, we are still there. Even though we can convey some ideas about the acts and motivations of our clients, and even though deep down in their conscience, the judges will have been convinced by these purely financial law arguments, when we read the judgment that we managed to get in the end, we find little or no trace of reasoning on these grounds. This is the reason why we have to offer a way out to these non-specialized judges and to formulate as many technical procedural arguments as possible. It is not so difficult for us French lawyers, as France is a famously over-regulated state with loads of agencies, and we can import technicalities from other fields such as tax law or antitrust law. And for instance, the antitrust procedure is 10 years ahead of the AMF procedure, and it is then quite easy to use procedural requirements of the former against the latter.
Great. Thank you very much, Guillaume. And if I ever need to get off on a technicality, I know who to call. I think that brings us to our third and final topic, which is looking at emerging trends and key considerations from enforcement cases. And let's stay with France. Martin and Guillaume, what trends and considerations are you seeing from your enforcement matters?
Thanks, Chris. Look, one of the most worrying and unpleasant trends currently that I see for financial institutions relates to the subsequent class actions. This is an obvious risk that financial institutions now face after the enforcement proceedings are made public. Class actions are a group of plaintiffs deciding to initiate civil action before the court on the basis of a sanction issued by the regulator. In this case, a professional breach of good conduct becomes a civil tort, which could trigger the award of damages for the claimants. There are 3 class actions that have recently been brought against financial institutions in France. one against Natixis, following a 35 million euros fine imposed by the AMF Enforcement Committee, reduced to 20 million euros by the Supreme Court. Guillaume is aware of this case. The AMF found that Natixis failed to comply with its obligation regarding the management fees for its formula-based funds. The class action is still ongoing, but it's a key issue. There are also two class actions that have been initiated against BNP Paribas following criminal court decisions, not formally the AMF, but criminal courts. One has been declared time barred, and the other one is quite impressive because BNP Paribas was sentenced to pay 127 million euros to plaintiff by the Criminal Court of Paris. There is a separate class action which is on hold, but this risk of subsequent class action, group action is something that we see in France and is very worrying for financial institutions. Guillaume, what about the appellate courts?
Well, an emerging trend in enforcement procedures at the appeals level is to draw full conclusions from the fact that most financial law at the national French level comes from EU regulation. We therefore are used to raising preliminary questions to be put to the ECJ. We try and see whether other national regulation authorities have faced similar issues similar to the ones we are facing. And finally, if we do not get the expected good judgment from the Supreme Court, we do not hesitate to file a complaint with the European Commission, whether it be a formal complaint or an informal one. Going to the Commission is a bit of a long shot, I have to admit, but it is very useful in the long term to have the European Commission informed that France has such a baroque conception of common European finance law concepts. In return, it is very useful for people like me, Supreme Court barristers, to be seen as having the ability to expose the mistakes made by the French Supreme Court at a higher level. In the same spirit, we do not hesitate to go with our aforementioned technicalities before the European Court of Human Rights.
Great, thank you very much, Guillaume. Andy, do you have any insight into the trends in enforcement cases we're seeing in England?
Yeah, no, I've had a look at this, but it's probably fair to say, and the FCA has such a wide remit and so many firms that it's be hard to say they don't act thematically, as it were. There really are, if you look at the last few final notices, the last few tribunal decisions, or at any time really in the last 10 years, it's partly just what happens to have come onto their radar and partly bigger political considerations, things like the LIBOR scandal or the foreign exchange scandal, where they have to act, or there are just a number of cases to do. So with that caveat, I think the three areas one can perhaps see a lot of interest and movement at the moment. Firstly, market spoofing, market manipulation, these type of highly technical areas. We're seeing it right across the globe. Within the last 10 days, we've had a final decision notice come out in Baptiste. It's going to the tribunal, as I understand from reading the website. It involves detailed technical evidence about whether trades were spoof trades, without an intention to purchase, or whether they were done for an innocent reason. And I think that is an area the FCA are looking at very hard. Secondly, integrity is very much up for grabs. I mentioned the decision in Mr. Tinney, probably the most important recent decision coming out of the tribunal, in which they've made some comments about the meaning of integrity, following up and reached a different decision to the RDC. This follows the Court of Appeal decision in a case called Wingate recently, which had two conflicting decisions to resolve about, is integrity primarily a subjective concept or an objective concept? Is it really about not acting as reasonable people would in the same circumstances, or do you really have to be consciously appreciative of your wrongdoing, or at least risk-taking? And that's come up as well in the criminal context in cases following on from the LIBOR scandal. And I think we're going to see a lot of interest from the FCA in that, particularly as the new SMCR regime comes in, which means senior individuals in regulated firms now have a different status than they've had for the 20 years previously. They're no longer going to be approved persons with controlled functions in a regime we're all very familiar with. The relationship between the firm and its staff sponsoring people in those levels is going to change, and that will inevitably bring cases. And thirdly, money laundering. There's been some comment recently, and you'll all have seen it, about the fact the FCA have apparently dropped half of the criminal money laundering investigations which they had taken forward. And obviously that may well have been simply for reasons that on the facts of that case, as Chris has said, that's what they want to do. There was no case to answer, but it's caused some comment about where the FCA are going with criminal money laundering. At the same time, of course, in the more standard regulatory area of money laundering, they're being very active. And Martin mentioned a particularly large fine, I think it was BNP, or the largest fine in the last calendar year from the FCA was against Standard Chartered for money laundering, £0.2 million. So again, that's an area that there's obviously a lot of focus on, and obviously some quite difficult questions about when criminal procedures and other forms of regulatory procedure give you the best outcome. So with a crystal ball attempt, those are the three areas I think we could see a lot of movement in the next couple of years.
Absolutely, Andy. And just to add on the SMCR side, so this is the regime that regulates individuals at financial institutions, both from the sort of senior manager level down to everybody except for the receptionists and cleaning staff at a financial institution. It was put in place for the bigger firms in 2016, and then for everyone else at the back end of 2019. And I think everyone has been predicting since 2016 that there would be a flood of SMCR cases, and yet there's just been one final notice that's related to SMCR, and that would have been decided exactly the same on the previous regime. But I would second that there will certainly be a larger number of investigations and then settled final notices around SMCR. And I say that because the sorts of questions I'm seeing the FCA ask my clients are getting more detailed and appearing more strident when it comes to those senior managers in particular at firms. At one of the matters that I dealt with, the FCA started its first enforcement meeting by saying there's been a failure at this firm, and when there's been a corporate failure, there's always been an individual behind it, and we're going to find out who that is. In that case, they didn't find the individual, but I'm sure they will in the future, or at least they will investigate those individuals in the future and seek to bring actions against them. That brings our main topics to a close. We've asked for some questions from the audience in advance of the session, and I believe we've received one, which I will read out. And it's not an unexpected one, which is, how will Brexit impact cross-border enforcement? Martin, I wonder whether you have any thoughts on this.
Look, Chris, in my opinion, Brexit will not have a great impact on border enforcement in France, UK. Regarding the various professional obligations of good conduct, the home state regulator will still have jurisdiction. This means that post-Brexit, the FCA will be able to inspect and potentially to fine any financial institution that will be authorized to operate in the UK. And the same would apply for the IMF in France. On the market abuse and investigation side, the regulators have jurisdiction on any market abuse offense that is committed on the domestic market, regardless the location of the punishable person. This means that post-Brexit, if a UK trader manipulates the French market, the IMF will have jurisdiction over him even after Brexit. It would be like an offense committed by a Chinese or a US investor. The future status of the UK is not finalized yet. However, it is likely that the FCA will enter into mutual assistance agreements with the various EU regulators in order to be in a position to investigate via the assistance of its peers in Europe.
Great, thank you, Martin. Does anyone have any differing views on that?
No, I agree. I think the FCA has a lot of experience in international cooperation, both within and without the EU. It has a lot of experience in international cooperation with states where there are geopolitical tensions still. And I echo Martin. I would be very surprised if that is put at risk by Brexit. But who knows in that area?
Absolutely. No, I entirely agree. I think Brexit's going to have a lot of significance to the EU and in particular the UK, but this probably won't be one area.